Well, good morning. How's everybody?
Good morning.
All
Good
right.
morning.
Are we ready to go?
Yes, sir.
And sir, you are the appellant, so you get to go first.
All right. Good morning, everyone. May it please the court. This case is really simple, and it's simple because it presents pure questions of law.
And that's why you contend there's no problem with not having the transcript?
Correct, Your Honor. It's clear on its face. The record is clear on the face. It's about jurisdiction and standing. So first, the court declared that it didn't have jurisdiction to consider the mother's request for continuing child support for the adult disabled child. And that's just clearly not the law, particularly not here in the second DCA. Holmes versus Holmes, decided by this court in 1980, dismissed a portion of the wife's contempt. She was seeking child support for their college education, and the parties had agreed by contract that he would pay the college education for the children. And the court said the mother does have standing to enforce that. In fact, she's the only one that has standing to enforce that. Again, in Smith versus Smith in 1986, this court came to the same result. And what we have here is a child who's been disabled his whole life. And the final judgment essentially put the burden of proof on the mother, who was then the primary custodian or primary caregiver of the disabled adult child. And she had to introduce evidence that the child needed support beyond his 18th year. Well, that was the final judgment. The amended final judgment, which controls here, actually reversed the burden of proof and said, okay, the child is disabled. His support's going to continue unless and until father enters some evidence that it should be terminated. So what we have here is the trial court just simply made a mistake. The trial court applied the terms of the final judgment rather than the subsequent controlling amended final judgment. So that's the issue on standing. With respect to jurisdiction, first, I think we can all agree that every circuit court in the state has subject matter jurisdiction over probate matters. The question is whether or not she can enforce whether or not she could grant any relief. She said she lost jurisdiction. If the first final judgment was reviewed, I suppose that would be true, because this court has made clear that the court's jurisdiction ends when there remains no judicial labor to be done in the case. Well, if we apply the first final judgment, I guess that's true, because Benjamin's child support terminated when he was 18 unless mom introduced more evidence. So the trial court, when looking at that final judgment, said, look, there's no more judicial labor remaining. This case was terminated when the child turned 18 and aged out. But if you look at the amended final judgment, which was entered before the boy was 18, then the burden shifts to the father. So the court does have continuing jurisdiction, just like in any other case where the parties are a minor child. The parties have minor children, and the jurisdiction continues. It's the same here. And there can be no doubt that Benjamin needs this support. So the only questions here are of law. Did the trial court err in essentially applying the wrong order to the case, and did the trial court err in saying that it had no jurisdiction to determine the issue because mother didn't have standing, the child had to bring it?
Didn't it duplicate what was going on in the guardianship case? Didn't Lutheran services have standing for all this? And weren't they doing their job?
That was part of the problem, Judge, is that was never made clear if we go back and look at the record. So two simple issues. I think the trial court erred on both of them. They're a matter of law. The standards de novo review. That's what I have right now. I would like to reserve 5 minutes.
Okay, you got it. Thank you. Reply?
Yes, thank you, Your Honors. Angela Flaherty on behalf of the former husband, appellee. I think without a transcript in this case, the question is going to be whether the findings within the very lengthy order support or allow the court to identify that any language, the slightly modified language in the amended final judgment does shift the burden. I would point, I see your lips moving, but I don't hear you, Judge Smith.
My speaker will come on. In
A little bit closer to the mic.
So my question is, you say it's slightly different, but in essence, it's considerably different because it allows the amended final judgment allows the trial and gives the trial court continuing jurisdiction. Because I'm looking at certain provisions of this, in particular where it talks about termination of the support, I believe that's paragraph 6. It says that it's subject to paragraph 5 section above, which is B being the extension of the support, right? And so the termination doesn't occur because there's an extension here for the oldest child that will continue. And then it says here that the above payments for this child shall continue regardless of the child's age or marital status until the disability no longer exists. And here, based on, and like you said, we only have the findings that the court can look at here, and we're confined to that. In looking at those findings, and I don't see here where the disability no longer existed. Correct?
Sorry, I apologize. There was a break.
And I'm looking at the motion that was filed by the former husband. I believe he says something to the effect that the child is 100% disabled, completely reliant on, dependent upon the parents here. So I don't see how you can say that the terms are slightly different.
Judge, if I may reply to that, because I do actually think this is where we come into a significant problem without having a transcript. And that's one, I'm so sorry, I see your lips moving again, but I do not hear you.
I simply said, explain that.
Okay, sorry. Thank you, Judge. That in this case, our position at both in all of the filings, and I'm not necessarily sure which of the motions you were just referencing, and I know throughout the appellant brief and the reply brief, there were discussions of an admission that dad admits this child is disabled. It's very important to note that it is dad's admissions is now disabled. And I don't think you can read in either the original final judgment or the amended final judgment that there is a finding that the child is disabled and, more importantly, dependent. I want us all to be making or I would ask the court to make a distinct note, because the standard isn't disability. It's not even competency, it's dependency from a financial perspective. So if there was a predetermination in that amended final judgment that this child was disabled to the extent he was going to be dependent without any sources of support, as testified to by a physician, then the child support would continue. This is not.
Okay, so if I'm looking at the July 13, 2018 motion for contempt that was filed by the former husband, paragraph 4.
Correct.
In the motion, it states one of the parties' minor children has profound nonverbal autism and is 100% disabled. Then the former husband goes on to state that following entry of the final judgment, this is paragraph 9, the parties have proceeded for the last 10 years, substantially sharing the caregiving needs of the minor child who has since reached the age of majority but remains needing complete care by his parents.
As of 2018, when that motion was filed, and that it was the evidence showed, I'm sorry.
The last 10 years pretty much brings it forward, right?
So no, I think what it said was they needed support, and then he's now completely dependent on the quote parents. And Judge, where you see in both the record evidence, not necessarily the transcript that hasn't been provided, but the findings is, and it's a particular note, this child was not disabled. He had never been identified as disabled at the time of the final judgment or the amended final judgment. And the amended final judgment does not say he is disabled. And in fact, the findings in the order under appeal show that he was not even dependent on the parents or in the parents' care from 2003 through 2012. And it was in 2008 that he emancipated, 2010 that a guardianship was established, and 2011 that he was first identified as disabled, which was 3 years after.
So reconcile your argument with the amended final judgment, paragraph 5B, which states, so long as this child remains mentally or physically disabled. So are you saying that at the time of the amended final judgment that that language did not mean that the child was mentally or physically disabled?
I am saying that if,
Here, the child
sorry, it looked like you stopped.
it said, and it continues, the child is incapable of providing for his own support. Are you saying that that doesn't mean the child was disabled at the time of the amended final judgment, mentally or physically?
Kind of. I'm saying that if the amended final judgment intended to make a finding that the child is disabled and child support shall continue past emancipation date, that's what it would have said, period. Instead, it has language that says it will continue if a competent, and then it has 3 or 4 provisions within that paragraph. It is our position that that did not, it further clarified the original final judgment. It did not shift the burden. If it shifted the burden, there would not have been conditioned precedents to meet for it to continue. It would have simply said, this child is dependent and disabled to the extent that he cannot receive any support and is dependent on his parents. From our perspective, that isn't an inference that should be made now 20 years later or 12 years later, because it very easily could have said that. When there's an argument that, well, there was a rehearing, then there's an amended final judgment, and the purpose of all of that, none of that's in the record. None of that's even in motions. The motion for rehearing didn't even identify that. None of that is on appeal, but we've all seen many either marital settlement agreements or final judgments where parties say child support shall continue and shall not terminate pursuant to these statutory factors. At that point, the burden would have shifted to dad, where if he ever was no longer dependent or was no longer disabled, he would then file a supplemental petition to modify terminate. While we think that additional clarifying language identified specifically what the court would be looking for later, if mom were to ask to continue the support, we do not believe it shifted the burden. And we think that the findings of the appellate court, which can't essentially be disputed as we sit here today, because there's no transcript as to what either party testified to regarding what was occurring at that time, can't be disputed. And the findings identify that there was not a finding in compliance. There was nothing, there's no testimony, there's no record. And in fact, the record evidence from the actual exhibits contradicts that, that assertion being made by appellant, because we know this child was not found disabled for the first time until after he emancipated.
Well, the statute requires it be done before the child turned 18. Right, under 743, isn't that a statutory requirement? Must be either adjudicated or be pending before the dissolution. But my question is, what did the mother do with all the money she was getting?
Well,
The child wasn't with her. She got all the money from Social Security. She got all the money from Lee County. She's collecting child support for a long period of time, not supporting the child. Where's all the money?
That
Do we
was
know?
the sub. Yes, sir. I'm sorry. I thought you were done.
I was done.
So if you read the entirety of the order, obviously was that the parties testified at length in that regard. Evidence was submitted, and there are the multiple findings as to all of the credits that the father is supposed to be entitled to.
Well, do you understand my question? What did she do with the money? Does the record show that? Because she signed a waiver of accounting when she was a guardian. I don't have to account for anything. So do we know where the money went? She was receiving quite a bit of funds.
I think based on the findings and ultimately the current guardianship case where she's not the guardian and the child lives with dad, is that she used them for her personal gain. The primary issue that was the subject, and
there was no enforcement or payback proceeding instituted. It's all about her wanting more money, essentially.
Well, more money, and she owes back money. There is a reservation of jurisdiction in this order under appeal that amount has to be addressed. And the house that she bought, putting in her name rather than the child's name, as the evidence showed, is currently the subject of the existing guardianship case. And Your Honors, I did want to make a couple. I think I have identified as to why we think that this language does not clearly shift the burden, as is the position of the appellant, and why we think the transcript is needed to know what each party testified to as to what was occurring, who testified, was the child disabled to the extent he was dependent.
Well, let me just clarify one thing. You used the word disabled. And I don't think anyone disputes the disability, but it's legal dependency that we're talking about. The child was never legally declared dependent prior to age 18. Is that true or false?
That is true. That is
disability
our
is kind of a red herring.
Our position is, while everyone keeps in the appellate brief in that using the word disabled, that is not the legal point pursuant to the legal authority. And we know, which can't be contested, that in fact, it's uncontested, the child was not dependent on these parties at the time he emancipated, because that's a finding not only without a transcript to dispute, but also the actual records confirming that are exhibits, which you do have within the appellate record. So from our perspective, that kind of resolves the issue from, did the court make the correct ruling, even though it incorrectly referenced the original final judgment versus the amended final judgment. And that can clearly be seen, that the harmless error response to that is neither one of the parents are the quote beneficiary of this ruling one way or the other. It simply means the financial needs of this child are being addressed in the guardianship case, and that if at some point he is financially dependent on his parents, that action would be instituted where both parties' responsibilities would be addressed. So there's no prejudice to the child. In fact, the result with either reference would be the same, because there is no single piece in this record, in this appellate record, that said this child was dependent before he became an adult rather than after he became an adult. Judges, and I would like to make one last point separate from our position in that regard. If the court disagrees, the appellate brief simply says, hey, child support should continue, or should say, hey, child support should continue. That we think the lower court got it wrong. We think that the dependency issue isn't the actual issue. We think it's the disability issue. So you guys need to go back and say that child support can be maintained in this case in the lower court. I wanted to point out to the court, both in the briefs, the order itself, and the court and the minutes from the hearings, the court considered all of that evidence, this wasn't a simple motion to dismiss on jurisdiction. They had both parties submit proposed judgments in the event that the court decided child support should continue. All of that is in the hard evidentiary records, child support guidelines, worksheets, etc. So this shouldn't be let's just start over. All of that evidence was presented, those orders were presented, and more importantly, the issues on the mother taking the child's home, the accounting, the Liz pendants, none of that is even the subject of the appeal, and the brief bootstraps on saying, hey, even though I'm asking you to really only make this one ruling jurisdictionally, you need to take away every single thing that occurred in this matter, when we do not believe there's any legal basis to do so. A, we think that the order should just be upheld, but B, if your honors feel that child support can continue and the burden was on the father, that was litigated. This trial, all of those issues are resolved. It's simply a matter of sending this back down to the lower court to say, okay, so we will have an ongoing child support for this child, even though you're litigating it also in guardianship court. But the evidence as to where we were as of the date of that trial introduced, both parties submitted proposed final judgments. The counsel for the father was simply requested to submit two proposed final judgments, one supporting our argument that the child did not become dependent until after he turned 18, and a second, if the child support should continue, what did the numbers look like?
All right, thank you. Mr. Chinopoulos, you have 5 minutes for rebuttal. Mr. Chinopoulos, your microphone's on mute. Your microphone's on mute.
I apologize, Your Honor.
That's okay. We're learning sign language here. You have 5 minutes rebuttal if you want to say anything.
Thank you, sir. First of all, to take the position that the child was never adjudicated dependent is simply ridiculous. This child was born autistic, and he has been dependent his whole life. In fact, he did spend some time away from his parents, as was noted. He was in a school in Kansas that was being paid for by Lee County, and he was still
who is the guardian? Who is the legal guardian? Is it still Lutheran Services?
It is now, yes.
All right. Who has standing to enforce any child support that might be due and owing somehow, somewhere? Is it Lutheran guardian or the mother who doesn't have the child? Is owed nothing?
I think up to the point that we're talking about here, Judge, the mother is owed back child support for the time that she had the child. For anything going forward, it might be due Lutheran Services, but the court doesn't expect that we give our child one shoe. We give them two shoes, and the other party, we've made them an interest-free loan. So mother,
we don't give the shoes to the mother. The child gets the shoes, not the mother. Here, the mother's living high in the hog with child support money from all kinds of people. Lee County, Social Security, the dad. He's overpaid. She's still looking for more money. It just seems something odd with that picture when there's a legal guardian and she filed waivers. She put the house in her name. I mean, this looks like something not dealing with child support or dependency, but trying to cash in on a disability. And that doesn't seem appropriate.
Yeah, that's certainly not the case, Judge. But for consideration today, we're talking about standing in jurisdiction.
Right.
And my opposing counsel has made the argument that there's no standing because the child was never adjudicated dependent. Well, he was adjudicated dependent in 2010. He turned 18 in 2008, and the dependency application was filed before he was 18. Didn't get determined by the state until after he was 18. So he filed for it before 18. He was also adjudicated disabled, Judge, when Lee County school system sent him to another school, a special facility for his special needs, although the parents were still his guardian then. Mother was his guardian after the divorce and until Lutheran Services took over. So he was certainly adjudicated disabled, and that's why
did the mom seek an order for continued support past BES turning 18?
Well, yes, that's what the supplemental was all about, Judge, and that's why the burden changes in the supplemental order or supplemental judgment, final judgment, saying that, hey, he is disabled, and if his disability is somehow cured or dissolved, then hey, father, you can present evidence to reduce or eliminate this child support.
All right, you've got about a minute and a half if you need to use it.
So, Judge, or Your Honors, I think that the mother is owed child support for the time that she supported the child. No, the mother doesn't buy the child one shoe and expect him to deal with it. The mother buys the child 2 shoes and thereafter or thereby made the father an interest-free loan until she gets her child support back, paying his share of those shoes. And that's what we're talking about here. All this other stuff about the house and everything else is not relevant to today's proceedings. And Judge, we would vehemently object to this court considering that, in that those cases are currently before the trial court for adjudication. And I don't think it's proper for the appellate court to consider them.
All right, very good. Thank you both. Well argued. You may exit unless you want to stay around and listen to the next case.
Thank you, Your Honors.
Thank you.
Your Honors.
We'll call the next case, which is Pediatrics versus Wausau Insurance.